Thanks for having me back. I've come to a prior iteration of this class a couple years ago, and it was pretty awesome, and I'm really happy to be here today. It's very cool that you all have taken time out of your super busy schedules to take this class. I think it's a really good program. So I'm really glad to be here. Like Greg mentioned, I'm at Landy Bennett Blumstein. I still actually serve as Maniluk's general counsel, but from the firm, at least for now, which is pretty cool. And I have a presentation to give on the legal framework of ANELP. A little bit else about me: I have 2 kids, a son who's 3 and a daughter who's 5. And we've been living up in Kotzebue for the last year and a half and just moved back down to be city people again. Scott was our neighbor up there, which was pretty cool. So it's kind of a cool surprise to see him in this room when I walked in. So yeah, might as well get started. I'm going to talk a little bit about the historical law that kind of led up to ANELP, or that provided some of the context that ANELP was passed in. I know that's a big focus of the class. It's cool to see Dave's book. He was a major mentor of mine starting when I was 15, and I'm at the firm he practiced at all those years, which is kind of cool. So it's neat you're reading his book that I rely on all the time. Who's doing is that you? Okay. Okay. I definitely will. And feel free to stop and ask for clarification if I'm not making sense, okay? Always feel free to interrupt. So Europe and the savage. There's imagery, if you look in old, like 11th century or old European art of the savage, right? There's always this enemy that has like 3 heads, is not a human, and that really those images really were a lot of the foundation of American Indian law. So in the 11th century, Crusades was the first large-scale effort to implement universal authority over non-Christian peoples outside of Europe. In 1436, there was a papal bull called Romanus Pontifex regarding Portugal, and basically this just stays out. And then in 1492, Spain conquered Americas based on legal principles of the Crusades. And then in 1497, England chartered of discovery to John Cabot, later Sir Humphrey Gilbert, Sir Walter Raleigh, the Virginia Company, all these familiar names. So basically this slide is just showing there was this history starting in the 11th century of Europeans going out into out to lands inhabited by savages and taking their land and resources. So this started in the 11th century and led up to 1497 when John Cabot and all these other folks, the Virginia Company, headed over to U.S. shores. Next, please. So the Proclamation of 1763 followed the French and Indian War. It resulted from treaties between England and tribes. It declared the territory beyond the Appalachians off limits to settlers, and such territory was Indian country where tribal law prevailed. Tribes were treated as sovereign nations at this time in U.S. history. And you have to keep in mind that by the mid-1700s, Russia claimed Alaska with minimal and scattered possessions. So there were like 550 Russians here, but Russia said this was theirs. So next slide, please. The U.S. Constitution, 1789. Article 1, Section 8 is the biggie here. It delegated power of government to Congress from the people, which is such a cool concept that the power comes from us to the government. I just find that so fascinating. But some of the powers include taxation, borrowing money, and regulating commerce with foreign nations and among the several states and with the Indian tribes. That's an article in the U.S. Constitution that is just so critical in U.S. tribal relations. And this talks more about sort of what that means, but also Article 4 Supremacy Clause says the Constitution and laws and treaties made under the Constitution are the supreme law of the land, and federal law preempts state constitutions and laws. So we'll see sort of in the following pages some of the implications of this very important provision in the U.S. Constitution that has really affected all of our lives today.
Liz, in the Commerce Clause in the Constitution, among that list, that could be read as putting Indian tribes on the same status as the several states and as foreign nations. Is that right?
It could be read that way, or you could be John Marshall and read it as a sui generis, kind of unique status, which is what they did in McIntosh. So if you go to the next slide, I think we'll talk about that. But yeah, you could read it like in that way. But I guess if actually go back one more time, sorry. But you do, this is where you can sort of imagine a triangle. There's the federal government, there's foreign nations. Actually, that's a square, but in my mind, I just see the federal government, the state, and then tribes. So these three types of entities within the boundaries of the United States. Okay, next slide, please. Thanks. So Johnson versus McIntosh. So there's this guy named John Marshall, Chief Justice John Marshall, and he rendered the first 3 foundational Indian law opinions. He wrote a bunch of other opinions too, but I know him mostly because of these 3, the Marshall Trilogy, as they're called. And this is the first one, Johnson v. McIntosh. And there was, so this is this, during this time when everybody's settling Indian lands in the lower 48 and taking their stuff. So the Illinois and Pinkeshaw Nation sold land to this guy, Johnson, in 1775. So then post-American Revolution, the U.S. acquired some land by the Treaty of Greenville after the 1794 Battle of Fallen Timbers. In 1818, the U.S. sold some of that same land to McIntosh. So you have tribes selling land to Johnson, and then you have the U.S. selling some of the same property to McIntosh. Johnson claimed that he had better title than McIntosh because he bought it first, saying you can't just sell my land after I bought it, but McIntosh won. And so this sets out the legal principles that the doctrine of discovery gives title to the discoverer. And but it's only against other European governments. So the European governments get to be, they have these special powers to discover. And the rights of Indians, in this case, were not entirely disregarded, but they are impaired to a considerable extent. So Indians have some rights, tribes have some rights, but mainly it's here, one of the most important legal principles is this doctrine of discovery. And maybe you've heard that term before, but it's really the basis for how European governments took native land. We discovered it. It doesn't matter there were people there. It doesn't matter they had governments and cultures and languages and religions. We're Europeans and we discovered it, so it's ours. And that's what this lawsuit emphasizes. And so, next slide, please. Cherokee Nation in 1831 is the second in the Marshall Trilogy. And that's where these questions were asked. So are Indian nations foreign nations? No. They are this special kind of nation that we're going to make up in this opinion, which are domestic dependent nations. That's a new term of art that Marshall made up. So they are domestic, being within the borders of the U.S., and they are dependent on the United States for protection. And that's mainly from the states, because the states, when they got their, when they passed their statehood acts, they were granted the ability to select lands in the U.S. And so the feds were basically needing to protect Indians from the states and their land. And they're also nations with inherent sovereignty existing before the U.S. Constitution. So domestic dependent nations. I'm not sure that makes me feel very cool, like the native village of Kotzebue is a domestic dependent nation. I don't know. Yeah, okay. Next slide, please. So then we get, this is the third case in the trilogy, the Marshall Trilogy, Worcester v. Georgia from 1832. These are all Supreme Court decisions. So the U.S. Cherokee Treaty guaranteed Cherokee tribal government on reservation. They said that there's a reservation and the tribe gets to govern within those borders. Georgia law required a license to go on the Cherokee reservation. Worcester didn't have a license. He was going on the reservation. I think he was a missionary. And he was arrested and jailed by Georgia. So does Georgia law supersede the U.S. treaty? That was the question. Next slide, please. So basically, no, the U.S. law governs. So federal powers. These are some of the main points here of that case. So the Constitution grants power to Congress to regulate commerce with the Indian tribes. That section of the Constitution we already looked at. The laws made under the Constitution are the supreme law of the land, and under this case, federal powers over Indian affairs are plenary. They're complete, not absolute, but it preempts state power, and you can't violate the U.S. Constitution. So plenary power, that's the major theme here, plenary power. The power to basically say, the feds can say basically what they want. They have ultimate control, complete control, not absolute, but complete. Next slide, please. Okay, so now we get into sort of what inherent tribal powers are. Does anybody have any questions so far?
Are the slides going to be on Blackboard?
If it's okay with Liz, we will
Yeah.
post her slides. Okay, great.
Yeah, sure. Yeah. Okay, so some of the powers that tribes have are, and case law solidifies this, so over tribal members and territory, tribes have power to punish crimes, adjudicate internal disputes over tribal membership, domestic relations, and inheritance, those things that go on between tribal members. And then down in lower 48 states on reservations, when they're not PL 280 states, to punish crimes. And then over territory, tribes have inherent power to tax and regulate members and non-members. So that's sort of reservation-based tribes. In Alaska, of course, we're different, and so we'll talk about that later. Tribes also have powers over non-members, though, who are in consensual relationships with a tribe or a tribal member, and perhaps, if necessary, to protect political integrity, economic security, or the health and welfare of the tribe. And so this slide represents a lot of different case law that's come through the courts that, because all these different things are just tried. You have to see, okay, so will the courts recognize enforcement or of a divorce between two tribal members, and like a tribe will exercise jurisdiction over that, and then one of the people getting divorced is mad, and they're like, no, tribe, you don't have jurisdiction over me. So they go to a different court and challenge that. And so it's just like sort of piecemeal that the different powers are defined. And especially, so when it comes to tribal members' relationships with each other, that's your best bet that tribal jurisdiction will be found there. But when it comes to tribal members and non-native people, tribal members or Indians who are enrolled in a different tribe, there's more analysis there, or tribal members and non-natives at all, things are challenged all the time. So that last bullet actually represents a case called like Montana versus somebody, I can't remember. And these factors were set out as a possibility for having jurisdiction over non-members. And jurisdiction matters because it's like there's a tribal government trying to govern, and when people don't behave, you need to be able to have consequences and enforce them. And so this is part of like, how do we enforce consequences? How do we keep our communities safe? How do we maintain law and order, and that type of question? So it's not just jurisdiction for jurisdiction's sake. It's jurisdiction because you want to have, you know, a healthy community. Yeah.
So governmental entities, states, cities, governmental entities generally have these same sorts of powers. And the question that came up over the years is what Liz is talking about. You know, do the states have, or do the tribes have any of these powers? Do they have similar powers? Are they limited? And it really has taken on a case-by-case basis to determine from court decisions interpreting the Constitution, well, a tribe can do this, but it can't do that. A tribe can do this, but it can't do that. And at the end of the day, the government powers really are the powers that are the all-encompassing power, and tribes may or may not have similar powers as governments themselves.
Yeah. Okay.
Can I ask you a question then?
Yeah.
When that comes up, sometimes if you're on a reservation and it's a the tribe does govern something, like if they were to give a divorce and you go outside, or they don't want to give it, can you go outside of the tribe and then the government does recognize it? Is it recognized that way if you go off the reservation?
Yeah, it depends. And like in Alaska, one of the most recent examples of the state enforcing tribal orders, court orders, is a case that came out of Tlingit Haida, where the court affirmed the right of Tlingit Haida to issue child support orders. And there's this principle of comity under public law PL 280, and I don't think I even go into that in this presentation. So this principle of comity that says that under PL 280, which is a law passed by the federal government that gave states the ability to regulate some civil powers in Native communities, it says that tribes have the tribes in the state have concurrent jurisdiction, and there should be comity. So concurrent jurisdiction meaning they both have jurisdiction. So like the tribe or the state could hear a certain type of case, like civil dispute, and then the comity principle means that they should recognize each other's orders and decisions. So in this Tlingit Haida case that I think came out in March in Alaska, the court recognized that tribes have the ability to issue these child support orders, and that the state needs to recognize them and enforce them.
The order is recognized.
Yeah, but that, like, really practically speaking, that only takes you so far. And like, I don't know if you've seen some of the press on banishment lately, but like a few tribes have been banishing tribal members from their communities because they feel like they're too dangerous to be there, or whatever their reasons are. And sometimes it seems like there's a lot of confusion on the part of the state about whether or not they're supposed to enforce those banishment orders. It's probably going to be litigated. It has been litigated before, but so these questions don't always have like a firm answer. Like I think in some of the articles, some troopers were helping to enforce those orders, and then some were like, no, we are not allowed to. So it's kind of exciting to watch. There's not really, some things are established, so where there's the precedent, like now with this child support thing, in the next case it won't be disputed. It's like, yeah, enforce it. But there are these other issues that haven't been tested, and so you just kind of watch them and see how they turn out.
It's one of the cool things about practicing law. Yeah. You get to help make these laws every now and then.
Yeah. And in Alaska, like, more stuff is not answered than is answered. So if you want to become a lawyer and like fill in all those gaps, go for it. Yeah. Okay, so I think so these are still concepts that have come out of the Marshall Trilogy. So here is this Aboriginal title concept, and it's huge. It's a biggie. It's really important. It means like Native people have the exclusive right to use and occupancy, also called a usufructuary right in the case law, But if you like write that in Word, it'll tell you it's not a real word, but it's in these cases. So anyways, the usufructuary right, the land of Native people is protected, that they have Aboriginal title over, is protected from trespass, and only Congress can extinguish Aboriginal title. So this is critical. Native people have a right to their customary and traditional homelands based on this concept of Aboriginal title. And it's not the same kind of title that white people get, that Europeans get, when they have like a paper title to a piece of property which goes, you know, down to the center of the earth up to the sky. It's very different from that fundamental property right that's recognized, you know, in European structures. It's a different thing where if you use it and occupy it, if the tribe uses it and occupies it, then they have Aboriginal title to it. So moving to the next slide, the 1867 Treaty of Cession. So Russia thought it owned Alaska, and because it's a European power, you know, other European countries agreed. And so, I mean, I'm not sure if any of your tribes sold their land to Russia, probably not, but Russia claimed it, and the U.S. recognized that and bought it from Russia in 1867. So the Treaty of Cession is super fascinating. It says that the inhabitants of the ceded territory, if they should prefer to remain in the ceded territory, they, with the exception of uncivilized native tribes, shall be admitted to the enjoyment of all the rights, advantages, and immunities of citizens of the United States, and shall be protected or maintained and protected in the free enjoyment of their liberty, property, and religion. The uncivilized tribes will be subject to such laws and regulations as the U.S. may from time to time adopt in regard to Aboriginal tribes of that country. So this is a fascinating provision in the Treaty of Cession by which the U.S. bought Russia or Alaska from Russia, because it says that the inhabitants of the ceded territory, so the people, except for the native people, if you're Russian or from wherever else, you get to basically be treated as a U.S. citizen. You get to enjoy, have the rights, advantages, and immunities of citizens of the U.S. You get to enjoy your liberty, property, and religion. But if you're native, then you don't. And if you're native, you will be subject to such laws and regulations as the U.S. may pass later. So they sort of punted the discussion about what rights Aboriginal people actually had here. But it's pretty racist if you think about it. It really sets people up on really different footings. But it's really part of that whole doctrine of discovery concept, the whole, you know, going back to the 11th century Europe, you know, with the savage being the bad guy who doesn't really have rights. It's very consistent with that approach. Yeah, next slide, please. So in 1884, the Organic Act, which created like civil rule in Alaska, because before that it was basically under military rule after the Treaty of Cession was passed. So in 1884, there's this provision in the Organic Act that says Indians or other persons in said district shall not be, so that's all of Alaska, they call it a district, shall not be disturbed in the possession of any lands actually in their use or occupation or now claimed by them, but the terms under which such persons may acquire title to such lands is reserved for future legislation by Congress. So this is kind of cool because now we have some rights. Like we, Indians, shall not be disturbed in the possession of any lands actually in their use or occupation. So acknowledging there may be an Aboriginal title claim there because Native people are using and occupying land. And then they kind of punted the question of how to resolve the Aboriginal title claims again and said, Congress can deal with it later. Congress has plenary power under the Marshall Trilogy, so Congress can exercise its plenary power later on and decide what to do with the Native people. Okay, next slide, please. Yep, okay, you're already there, cool. So in 1887, the federal government passed the General Allotment Act, the Dawes Act, and this was, it applied primarily to the lower 48, and it was part of this era. You can categorize Indian law in different eras. There was like the termination era where the feds were pretty much trying to shut down tribal existence and pretend like it didn't exist. But then there was the assimilation era, which said actually Native people, if you set up schools like Carlisle Indian School and send Native kids to boarding school, they can be civilized. We can kill the Indian and save the man. And so the General Allotment Act was passed in that era of assimilation, where the idea was to give Native people, what is it, like a hoe and some mules. What's that phrase? 3 something and a mule. Like make them farmers, give them some property so they can start being productive. Set them up in individual family units, not in more community-based units like they'd prior lived. So
3 acres and a mule.
yeah, 3 acres and a mule, or 160 acres and a mule. Yeah. So that was that concept. So, but it didn't really apply to Alaska. So in 1906, the Allotment Act was applied to Alaska, and it authorized the Secretary of the Interior to allot up to 160 acres of vacant, unappropriated, unreserved, non-mineral land in Alaska to any Indian, Aleut, or Eskimo of full or mixed blood, don't forget us mixed bloods, who reside in and is the head of a family or is 21 years of age. So basically this started giving people some land, which is cool. But then if you go to the next slide. So there's a Native Town Site Act too. So we're getting now into sort of what powers and what acts Congress took to address Alaska Native peoples. Because those initial 3 statutes said, we'll deal with it later, we'll deal with it later, we'll deal with it later, and now they're dealing with it. So with the Townsite Act, a Native Indian or Eskimo of Alaska who occupies and claims a tract of land in a trustee township and who desires to obtain a restricted deed for such tract should file application thereon in a form approved by the director of the Townsite trustee. So basically it was a way to give Native people land. It wasn't like super widely used. But
Yeah, that's the thing, given the communication that was available to people back then, Congress could pass lots of great laws to benefit the people, but back here in Alaska, if you lived in Kotzebue, chances are you're not going to hear about this or make an application or get that piece of paper that says you own something.
And the language barrier.
And the language barrier,
yeah,
exactly.
that too. Okay, so this is all though part of sort of this assimilation era where we can, bring Native people into modern American life and make them Americans. So go to the next slide, please. Okay. Oh, I was thinking in the 1934 Indian Reorganization Act. It ended the allotment era, which was basically 1887 to 1934. It set up a tribal revolving loan program. It had land protection provisions and tribal organization provisions. So tribes could organize under this statute, and actually many were. So in Alaska, they're what are called traditional councils, and they're federally recognized tribal governments that weren't established pursuant to the Indian Reorganization Act. And then you have Indian Reorganization Act tribes, and I think they're about 75, and they basically they were incorporated pursuant to this statute. They have like a more or less template articles of incorporation and bylaws that were primarily sort of facilitated by the local government agent, who was also a lot of times like the teacher, who was also like a missionary. All these functions were lumped into sort of one entity, one person, one family maybe. And so a lot of tribes did organize pursuant to the IRA. I know all but one in Northwest Alaska did. So all but no tax. So there are many, and they all have the same constitution, and a lot these days are actually working on amending those constitutions because they really, in some ways, they reflect the values of the community, but I mean, you can bet that more or less they're not really what the community would have drafted had they had the opportunity. I've actually looked in the archives down in Washington, D.C. to see what kind of correspondence happened around the adoption of these constitutions, and there's just not a whole lot of actual like Native people's dialogue recorded in the files. It's more like the local government agent was like, here's your bylaws and charter, go forth and conquer, go govern, which is kind of troubling, but it did recognize that tribes had some rights, and it set up some basic governing rights. You can pull up these constitutions online, just they're available on this tribal court clearinghouse website, and just Google some and you can read them. So they're kind of neat historical documents, but a lot of tribes are still using these IRA government documents. But mind you that there's not land associated with these governing bodies. So that's sort of so kind of keep that in the back of your mind. And I think we could go to the next slide, which marks the termination era. So up until this point, things have been looking okay for Native people. I mean, it wasn't like they were actually, I take that back. I don't know if boarding schools were really okay. I take that back. But this part just sucks. This is termination. This is 1945 to 61, where House Concurrent Resolution 108 Statement of Policy said that we're done with tribes. We're done with dealing with them. We're terminating tribes. So they terminated 109 tribes, impacting over 1 million acres of land and over 11,000 individuals. Sold lands. There was this end of the trust relationship. State judicial authority was imposed. End of tax exemptions, end of federal programs. Basically, this was the federal government saying, we're washing our hands of Native people. We're terminating our relationship with you. You need to just participate in American life and be Americans, and that's it.
So that reference to 109 tribes, 1.4 million acres of land, and 11,466 individuals, is that specific to Alaska?
No, that's the lower 48. And they're the ones who had land. So that's primarily the lower 48. Yeah. And the actual status of Alaska Native tribes, it wasn't even necessarily clear at that time. It was still this sort of there was confusion. So that was primarily the U.S. government, where basically those 109 tribes were like de-recognized, like you're no longer a tribe.
Okay, I was just curious that 11,000 people seemed kind of low to be lower 48 times.
Yeah, maybe that's wrong. I could double check it, but that's what I have. That's it.
So was that the total amount in existence at that time?
No.
So it just affected a certain
Yeah.
set.
Today there are 565 federally recognized tribes, or thereabouts.
109 were terminated.
Yeah. Yeah.
But
And was there a reason that set was chosen to terminate?
I'm not sure. I didn't spend a lot of, this is sort of I've usually spent more time researching the other stuff than this, but it does, actually, these are really good questions, and I do kind of want to look into these things more. Yeah.
But it's important to understand in construing laws, the Constitution is kind of the foundation, right? And then Congress can pass laws, some of which may be constitutionally based and some may not. So this was not any change to that fundamental body of law that defined the Constitution that affected Alaska Native American people. This was an act of Congress that really changed federal Indian policy. And that's what we're talking about. We're talking about what was the federal Indian policy and how's it changed? And what did it actually say in terms of land here in Alaska?
Yeah. And it's pretty, I think that's a really good point. It just goes to show what plenary power really is. You can, the Congress can grant rights, take them away, really at their own desire. So I think that's a good point. Moving to the next slide, statehood. I've heard stories from some elders who were around when the Statehood Act passed, and just like in Fairbanks, and people were just, there were parades, there was confetti, you know, they were walking around with American flags, and this elder was a kid and just didn't realize really what was happening, and that it was just huge, and that this elder was kind of sad that I mean but there are elements to the Statehood Act that are all right for us, so I'll just read it. So the Statehood Act, among other things, we're getting into land now, but among other things, it allowed Alaska to select 103 million acres of vacant, unappropriated, and unreserved lands. And this meaningful provision that the state and its people further disclaim all right or title in or to any property, including fishery rights, the right or title to which may be held by or for any Indian, Eskimo, or Aleut, or community thereof. The state and its people agree that unless otherwise provided by Congress, the property shall remain subject to the absolute disposition of the U.S. So the state was getting 103 million acres, and Alaska Natives filed protests to the selections of the state based on Aboriginal title. Next slide, please. Okay, so I'm going sort of chronologically, but so you got the 58 Alaska Statehood Act, you have the Self-Determination Act, which is sort of the present era we're in, whereby the feds decided, actually, we don't want to have a policy of termination anymore. We want self-determination. We believe that tribes actually are not going to disappear even if our policy is termination, so let's help empower them to be all that they could be. So there were amendments to the Indian Civil Rights Act of 1968. There was the Indian Self-Determination and Education Assistance Act of 1975. There was the Indian Child Welfare Act of 1978. The American Indian Religious Freedom Act of 1978, and then Tribes and States provisions. So all of these are examples of restorative acts where the feds were like, "Oops, we changed our mind, and we actually want to empower tribes." So these are just examples. There are probably more, and these are. So let's look at Indian Self-Determination Act, for example. That's a really meaningful statute. And I think a lot of you are probably familiar with it, but it allows tribes to compact and contract with the federal government to perform the programs, functions, services, and activities that the feds would otherwise be providing. So those activities and PFSAs, as they're referred to, are actually listed and published in the Federal Register. And a tribe can look and see, if it wants to compact or contract to perform those services, PFSAs, and they can enter into that compact and get the money and perform the service. And the idea being that tribes can be more effective in the provision of those PFSAs because they're there on the ground, they know their people, they're physically present whereby the feds may not actually be in Barrow or have personnel on the ground that can do the work. And so that is that's pretty huge. So Manila, where I work, or where I worked until recently, and who I still provide legal services for, it's a large part of that $90 million company is like Indian Health Service funds coming in, and then we, as a Manila, have the opportunity to provide the health care in a way that's at our hospital and in our 12 clinics that is as culturally appropriate as we can make it, and that just is consistent with the values of our people. And that's the goal there. So I think, another really important statute is the Indian Child Welfare Act. What is more precious to Native people than our kids, right? And we know that many are, just because of the nature of our communities, a lot of kids need to be taken out of their homes. So ICWA allows for tribes, it gives tribes rights to step in and intervene in cases in other courts and either be a party to that suit or remove and actually take the case to their own tribal court. And so it's a really powerful mechanism to keep kids home in their home communities. And everything isn't perfect under that. There's always, a lot of issues with that. But at least it's just a really great restorative act that recognizes that tribes have rights.
Our individual funding agreements that we have in our organizations fall under the Indian Self-Determination Act then, yes? Our individual, those are our compacts, our funding agreements fall under that act.
Yeah.
Yeah, you can really see historically this era from 1968 to 1978, same era as when ANCSA was adopted by Congress. It really, to a large extent, was a recognition, the beginning of a recognition again of Native American civil rights. And a lot of the foundational law that came from this period is law that we rely upon to grow today.
Yeah.
Under ICWA, if your tribe doesn't have a tribal court, can a family be seen under another tribal court?
So that's a neat question. Maybe people have more experience in this than I do, but like Kenaitze, for example, they take the position that, they will intervene regardless of where that kid is enrolled because and that's their practice. They're sort of more aggressive than a lot of other tribal governments and it's taking a risk. It's possible that somebody would say no, they don't have jurisdiction, but they do. But one of the issues that tribes often feel that they have is they don't have a tribal court established. They'll compact with the BIA to run an ICWA program, but they may not actually have. So they have the personnel on staff to be like the ICWA coordinator, who manages, they do a lot. They do so much to help, make sure the kids are okay, but they may not have an actual tribal court set up in their community. So the ICWA coordinator may, the tribe may intervene in a case that's happening in state law, but they may not ever remove to their own court system to have their own community members decide, where to place the kid and all that, because they don't have a court set up. But under those Indian Reorganization Act constitutions, it doesn't provide, there's no specific provision saying, and this is how you'll set up a court system, or this is what you need to do, this is what the tribe needs to do in order to set up a court system. But some tribes have. They feel like those IRA constitutions give them the authority to govern, and that having a court system is a really important part to being able to govern. And so they've just set up court systems. Or like in a lot of smaller communities, tribal councils will serve as the court. And so sometimes they do. I think Ambler's been doing that for a long time. They don't have a separate court system because they just don't have the resources for that, or capacity, infrastructure, whatever, but the council itself acts as that court. So they'll intervene, remove the case up to their community, and then decide what will happen with their community member's child.
I think it's also to watch the dynamic between OCS and ICWA, the partnership that happens there. I think that when you said there's limited resource, that's what feels bad to me, is that I think there's limited resource for for ICWA to be able to do what they want to be able to do too for our kids,
Yeah. There are totally limited resources. I think everybody feels like resources are limited there. But yeah, that's definitely an area that the more people that focus on it, the better. So there's been cool case law developed in that arena too within the last year, because previously the state, getting back to your question about recognizing, sort of recognizing tribal court orders and stuff, or participation, the state was requiring grandma to like full on file paperwork and all this stuff in order to say that she wanted to adopt her grandchild, which was ridiculous, because when people are living in the villages, there's not like a local attorney you can go see and be like, hey, can you drop my paperwork for me to submit to the court, because I want to keep my granddaughter home. So this state, I believe it was a Supreme Court decision, said that, and in that case, the grandma had repeatedly said in court, I want to adopt my grandchild, I want my grandchild, and just repeatedly made it very clear, like, hello, this is my grandchild. And the court recognized that that was valid, and there's been a regulation change and stuff, so it's like things are getting better, but I think you're right to focus on that element in this list of things, because it's our kids, right? And that's our future. And I also think about how that language in the Treaty of Cession that started us off like that, like people, so non-natives don't have rights, other people do have rights. It wasn't all that long ago. That was like my grandparents or great-grandparents' generation. Imagine that kind of historical trauma that's just continued to present day, So you think about those things and like, does this legal framework have something to do with the social traumas in our communities now? Probably, but yeah. So I think we can go on to the next. So in this whole context here, I threw in this slide to show that, our rights as Indigenous peoples are recognized internationally at this point. And there are all of these instruments of international law that recognize our rights, and a lot of them are aspirational documents. A lot of them, governments around the world aren't really fulfilling, but at least they're there. So there's the Charter of the UN, which was signed in 1945. There's the Universal Declaration of Human Rights, the International Convention on the Elimination of All Forms of Racial Discrimination, the International Covenant on Civil and Political Rights. There are all these things, and then kind of culminating in the, it's not even up there. These are actual treaties. They're treaties. They're the law of the land, right? And then there's also the UN Declaration on the Rights of Indigenous Peoples. So I think it's important to keep this in the mix as we're talking, just in the back of your mind. So next slide, please. So now we come to ANCSA, 1971. The Alaska Native Claims Settlement Act. So it recognized that Alaska Native communities, peoples, had Aboriginal title. Okay. Claims were made to over 100% of the state by Native people, because some territories overlap, right? ANCSA extinguished Aboriginal title. And I think the text is messed up there, because it extinguished our Aboriginal title but gave us $962.5 million to ANCSA corporations to be established under state law, conveyed 44 million acres to ANCSA corporations, and then basically said that, there's any other rights, there's no reservations here, any other claims to land based on Aboriginal title are squashed. So it was sort of like a swap. Like, we got 44 million acres. That was basically our compensation. So Aboriginal title is like a compensable right. And so we got almost $1 billion and 44 million acres. Yeah, I guess it is the 365 million acres that were claimed, which the feds extinguished our Aboriginal title to. Yeah.
How does NEPLA Indian Community
fit into the whole Nessun as being the only reservation.
Yeah, so I didn't write about this in here because I guess I was trying to keep it short. But Sheldon Jackson, anybody heard that name? Sheldon Jackson. He was what was his formal title? He was like the government representative guy in Alaska, the BIA education guy, but he was also a missionary. So he was working with Alaska Native communities around the time that, like 20 years before Carlisle Indian School got started. His philosophy was different from his contemporaries. He thought that Native people should stay in their villages, and that was how they were going to be successful, that taking them out, because there was this practice of taking people out of their villages and sending them to an urban center. He thought that wasn't going to work out very well. He helped people get reindeer herding started, and that was his big project, because it wasn't like and it was helping to get the whole goal was to get Native people to participate in capitalism, and so there were those reindeer husbandry enterprises. He encouraged the creation of reservations in Alaska. I think there were 105. I could be totally messing that up. It says in this book somewhere. Yeah, there were a lot. 81. Yeah, so there were reservations, and Metlakatla, I'm by no means an expert on Metlakatla, so if anybody else knows more than I do, just pipe up. But Metlakatla, so reservations were terminated by ANCSA. But people basically had an option. So Metlakatla opted to keep their reservation and not participate in ANCSA. So that's how that happened. But you should read the section in here, starting at page 81 on that, because, yeah. So we don't usually think of the fact that there were reservations here, right? But there were. Yep. And this totally talks about it. There's more detail. Yeah. So that's how that happened. Next slide, please.
So, sorry.
Oh, yeah.
So the Aboriginal kind of still applies to their reservations?
Yeah, yeah.
So that's how they're able to do like compacting and contracting through
Mhm.
with for healthcare services and things like that to run their services.
Yes,
I guess I'm
but
just trying to see the relationship between the ANCSA and regional health corporations and how they kind of play as a larger trend of health.
Okay. So it's because they're on the federally recognized tribes list. So there was sort of this back and forth, and I didn't put that in here. I suppose I could. I should be taking notes on like what else would be helpful. Plus recognized tribes list. And I should actually add reservations, because I think that would be helpful too, because it fits. I mean, it's totally part of this. So the federally recognized tribes list was adopted in 1994 or something like that. Eight a year, yeah. Because there just wasn't, everybody was like just confused about if tribes existed or not in Alaska. And after ANCSA passed, there was even more confusion. They just didn't know, well, are these the same types of entities that exist in the lower 48, or are they not? And they went back and forth. And finally, Ada Deer, when she was at the Department of Interior, was she the actual secretary?
She was,
or the assistant secretary?
Yeah, I think she was was she secretary or head of BIA?
I think she was head of BIA.
Yeah, head of BIA.
There's a statute that says every year BIA has to publish its list of federally recognized tribes, and so she did, and she included Alaska tribes on that list, and we've stayed on it ever since, which is kind of nice. They're not like, oh, never mind, you're not. Yeah, but it's on the basis of being a federally recognized tribe that everybody is compacting and contracting. But actually, too, the definition So there are numerous different definitions of Indian tribe, and the prevailing one under the Self-Determination Act includes federally recognized tribes and INCSA corporations. So we might start seeing, we haven't really seen INCSA for-profit corporations compacting, doing like Section 638 compacting as much. We might start seeing that more. I don't know.
Doesn't Siri give South Central Foundation?
Yeah, so the whole history of how Cook Inlet region ended up with tribal authority but not being a tribe is fascinating, and it's found in a combination of ANCSA and the Indian Self-Determination Act, and it's a good just kind of segue story. But so in Anchorage, Alaska, the headquarters of SERI, at the time the opportunity to begin compacting occurred, there was essentially a food fight over who was going to have access to this vast amount of federal money associated in working for the Indian Health Service. And it resulted in a lot of litigation. And the argument from SERI's perspective, and it took me a while to find all this case law, but the argument from SERI's perspective was that there was not an Indian tribe in Anchorage. There's one up in Eklutna, which is pretty close. There's one over in Knik. There's one across the bay in Tyonek, and then down south in Kenai. But in Anchorage, there was no tribe. And after that was all litigated and said and done, the court determined that it was bound to follow the law, and this is the federal district court. And the law says that if there is no tribe, then the government will do its compacting in a series of order. And the third order that happened for SERI and ultimately South Central Foundation was Alaska Native corporations in the absence of a tribal entity. And I think it might have been tribal entity, might have been IRA government, and then third Alaska Native Corporation. And that is what ultimately gave SERI the opportunity to access federal tribal money, not being a tribe itself, but have tribal authority, which has been delegated out to its nonprofits, South Central Foundation, Cook Inlet Tribal Council, Cook Inlet Housing Authority.
That all's fascinating.
Mm-hmm. It's,
And
it's a great case at the end of the day, and it was hard to find. I dug through the archives at SERI one day because somebody asked, well, how come we get to exercise tribal authority? And I certainly didn't know the answer to it.
Yeah. But like Nana doesn't get to, like nobody else gets to.
Nobody else
It's
gets
totally
to.
unique to this area. Yeah.
I don't know if that's the kind of argument you'd win today, especially with Eklutna.
Yeah. So ANCSA's impact to Aboriginal title is Section 4A extinguished all Aboriginal title, if any, in all federal land conveyances. 4B extinguished all Aboriginal titles, if any, including hunting and fishing rights. And 4C extinguished all claims based on any prior statute or treaty. So basically, our Aboriginal title claims were extinguished. It's funny that the feds think they can do that, but that goes back to the Marshall Trilogy and plenary power. They can do whatever they want to us. Yeah, so next slide. So this is, when I wrote this initially in 2014, when I made the first draft of this PowerPoint, consultation was a really big deal. It actually, in ANCSA itself, part of the whole, part of the statute says that, Congress wanted maximum participation by natives in decisions affecting their rights and property. So that's kind of cool. But then, so getting back to consultation, Executive Order 13175, which was ordered by President Clinton, requires the federal government wide consultation with tribes, Indian tribes, on matters that may impact the tribes. It applies to tribes recognized under the 1974 List Act, and then it's further implemented by the Presidential Memorandum, Tribal Consultation, Obama's reiteration, basically, of President Clinton's initial order. And that was a really big deal when Obama issued that letter to his agencies saying, consult, do what EO 13175 does. And that initiated, if you look over the past Obama administration, there was a lot of just more consultation than has ever occurred ever, including the tribal nations conferences that happen in DC. I don't know of a president who's spent that much time and energy on consultation, so that was kind of cool. It's not perfect by any means, but it's neat that that level of attention was given to consultation. But there's this interesting Stevens rider, which is cited there, that third bullet, and it requires consultation with ANCSA corporations on the same basis as tribes. ANCSA corporations aren't tribes, but they actually are defined as tribes, like in the Self-Determination Act and in like NAHASDA, the Native American Housing, whatever that stands for, the housing, our housing authorities are created under that act. And so this is sort of an interesting place where ANCSA corporations and tribes are sort of in the same arena. And I think we're going to see that going forward. So basically, like, your minds, our minds have to be thinking, like, how do we want our ANCSA corporations and our tribes to overlap in certain areas or not? So you may have seen lately on Facebook, there's been this post going around where Senator Murkowski's S-2012, her big, huge omnibus energy bill she's been working on for 6 years, is actually looking like it's going to pass. But it uses the NAHASDA definition of Indian tribes in it, and in that it gives federally recognized tribes and ANCSA corporations the ability to access these different energy programs like weatherization and different grants and stuff like that. So on Facebook, people are like, oh my God, ANCSA corporations aren't tribes. They're being treated as tribes. This is going to erode tribal sovereignty. This is bad for tribal sovereignty. We need to keep ANCSA corporations here, and we need to keep tribes here and recognize that they're different. And so it's sort of like everybody has different opinions on it. And so I think that is like our generation's discussion to have, and like we need to figure out how to use these tools in a way that helps us as peoples, right? Not just as shareholders or not just as tribal members. But I think this consultation situation sort of shows that, it demonstrates that sort of area of friction.
So this
Yeah.
last reference here is issued by who or what entity?
So that's the Congress, the United States Congress. And Senator Stevens was the master of putting riders into bills, like just inserting a little sentence here or there that really changes the dynamics. And this is one of those things. So Executive Order 13175 doesn't mention ANCSA corporations. It just talks about Indian tribal governments. But this Stevens rider, this is an actual statute. It was the appropriations bill, consolidated appropriations bill of 2004, where this language was included, and it said consultation under 13175 shall be ANCSA corporations. It didn't even say ANCSA, it just said Alaska Native corporations, so you have to assume they mean ANCSA corporations, and it's not like the C isn't capitalized, it's just a little, so it's like, well, which Alaska Native corporations do you mean? Like all? Anyways, so, but you just really quickly get to the conclusion, okay, he means those chartered pursuant to ANCSA shall be treated on the same basis as tribes. So that's Congress, who has plenary power, saying, and by statute, that all the federal agencies and the executive branch have to consult with ANCSA corporations on the same basis as tribes. And so it's been fun seeing the agencies figure out, what do we do? Like USDA, for example, had their consultation policy, and they each had to draft their own consultation policy because they do different types of work. So their consultation policy just includes ANCSA corporations in the definition of tribes. But then if you look at the Department of Interior consultation policy, and I was there when that was being worked on actually, there's one for tribal governments and there's one for ANCSA corporations. So different agencies are
I
treating these
worked on
things
the one for the
differently.
ANCSA corporations. They spent about a year working with tribes across the United States to develop their tribal consultation policy for the Department of Interior. And they spent about 3 months with Alaska Native corporations to develop the same policy. And we worked really hard on it. And ultimately, we had a number of choices. The least favored alternative being simply an addendum to the tribe's policy. And of course, that's what Interior chose to do. And these days, you can't even find the Alaska Native Corporation consultation policy on the Interior website. It's just, we worked really hard on it, wrote it down, and it's kind of forgotten these days. But Liz, the whole discussion, and we'll take the question in a second, the whole discussion here really calls out a fundamental tension created by ANCSA. So prior to ANCSA, federal Indian policy really concerned itself with tribes. And it was more and more clear what constituted a tribe, what tribal powers were. And in Alaska, all of a sudden, with the passage of ANCSA, federal Indian policy changes very radically by giving away this vast amount of land across Alaska to these entities that didn't even exist at the time, right? So creating brand new corporation entities, vesting them with title to millions of acres of land, and asking and taking away a lot of tribal rights. When at this point in Alaska, there was a lot of Alaska Native people that didn't know they were really tribal people. Perhaps in Southeast Alaska, they were much more tribally focused. But if you lived in Imana or in Kotzebue, you were, Inupiaq or you were Yupik. And so you weren't, part of a necessary tribe that surrounded this little village that you happened to live in. So those whole ideas of identification and the creation of ANCSA really resulted in this huge tension that exists to this very day, to this very moment. Right now, the United States Census, which puts people in boxes, right? And it's the census is putting people in boxes and counting them up, really determines how funding comes to tribes. And there's a huge fight right now because the questions that the census asks Native American people are much more extensive than they would ask a non-Native person. If you identify yourself as a Native person, you get drilled down in really deep in terms of, let's find out a little bit more about this person. And in this effort to pigeonhole people into boxes and ultimately determine funding. And right now, there's a tension between tribes and Alaska Native corporations that is very significant. It's millions and millions of dollars in how the census will determine designations in the next census.
Yeah. I think we could take one more question right now and then maybe try to wrap this up and then talk more.
So I guess my question comes down to the funding aspect of that as well. So the federal agencies under these statutes, if they have listed tribes as eligible entities, the corporations could potentially just compete with tribes for the funding sources.
That's the fear.
Yeah.
Yeah.
So do the agencies draft their own language in regard to that, or does the statutes that are written kind of overpower those?
So with some programs, I think they'll issue like a tiered approach, like we'll give first preference for this funding to go to tribes, and then next is like tribal organizations, like tribal nonprofits like Maniluk or something like that, or Cowarak maybe, and then ANC. So I think that's how some agencies do it. I don't have any really good examples though to give you. No.
And these answers, these legal answers are all found generally in regulations made by the agencies. So as we think about laws in general, the Constitution, statutes, and then regulations. So regulations are 3 levels down from the Constitution.
Yeah. Wait. Next slide. So Indian country, this is a statute. So Indian country is defined by 18 U.S.C. 1151. It describes the territorial scope of federal and tribal jurisdiction as reservations, all dependent Indian communities, and all Indian allotments. So this is relevant because if you go to the next slide, this case is a landmark case. I actually was at AFN as like a 15-year-old when Heather Kendall Miller had won the Ninth Circuit decision, and the energy in that room was amazing. Basically, that case, the Ninth Circuit court decision said there's Indian country in Alaska, that tribes can exercise authority over their territory, and they can tax, they can do whatever they need to govern on that territory. And I just remember Heather Kendall Miller, the Native American Rights Fund attorney who had brought that case, she was standing down in the front of the room, and there was this standing ovation. The whole room down at the Egan Center was standing up and just applauding and like, yes. And then the Supreme Court came in and reversed, and it was like, ha ha. So Venati, the native village of Venati, had previously been, they'd had a reservation land under that whole, that was created by executive order under the whole Sheldon Jackson program. 1.4 million acres, that's pretty darn huge. It was, so that reservation was shut down when ANELP passed. The land was then transferred to the village corporation. The village corporation transferred it back to the tribe, though. So the tribe had this land in fee. It wasn't in trust or anything. It was in fee, and they taxed the state that was doing a construction project. It was like it was a state contractor building a school there. Not really the best guys to be taxing, like when you're trying, you don't want to. Anyways, whatever. They claimed that the tribally owned land was Indian country. I think the state was kind of like, what? What? First, we don't want to pay the tax. Second, there's no Indian country here, guys. ANCSA extinguished that. So the U.S. Supreme Court held that ANCSA lands conveyed to the tribe were not Indian country. So essentially, this case says tribes in Alaska are sovereigns without territorial reach. But also the neat part of this case is that it really just addressed that land, and it didn't address some of the other statuses of lands, like allotments, which are held in trust by the feds. So maybe those would actually fit within the definitions of 1151. Didn't talk about native town sites, which could potentially fit within the definition. And then since then, there's been, but I think that clearly there's so much other stuff associated with this case that we could talk about, but I think it's just important to know that these ANCSA fee simple lands, even if they're held by the tribe, they're not automatically Indian country.
So this applies to the 44 million acres.
Yes. And I have not updated this presentation to show the recent development in the courts, the Akiachuk decision. So I need to make a note to update it. That says, so for quite some time now, so there's the Department of Interior has these these regulations governing how to take fee lands into trust for individual Indians or tribes. And the regulations around that have had this Alaska exclusion for, I don't even know how long, forever maybe, that says that Alaska tribes cannot, and individuals can't participate in having the, even applying for their fee lands to be taken into trust by the Secretary of the Interior. So a lawsuit's been going on for a long time. I think it's three or four tribes plus an individual sued, saying that this isn't allowed. You can't treat Alaska tribes differently than other tribes. We also have a right to be able to apply to have fee lands taken into trust. And this litigation went on for like 6 years, and the tribes just won, and the individual won. So now, and the Department of Interior also had changed the regulation to delete the Alaska exclusion so that the regulations applied equally to all tribes. And so basically the court recently dismissed the suit as moot. There's no more case or controversy because Alaska tribes are on equal footing as all other tribes. And so tribes in Alaska and individuals can apply to have their land taken into trust. And that puts us squarely within the framework of 18 U.S.C. 1151. But we'll just have to watch and see how this goes. And that could mean then that there is Indian country in Alaska. But I know there have been applications already submitted to the Secretary of the Interior. They haven't been acted on, so we'll see what that means. But you're starting to see the chatter, like I saw an ADN opinion piece. I didn't even read it, but it says, like, hopefully casinos won't come to Alaska. And like that's one of, there's a lot of fears around Indian country. There's a lot of fear that Native people will start doing these unethical things like gambling, or there's all these sort of standard fights in the lower 48 that you can see that happen where, and it's usually about money, like, and taxation.
Selling cigarettes,
yeah.
tax, right?
Yeah, and then like the state can't be taxing those businesses that are governed by the tribe on the tribe's Indian country, and so the state misses out. And so that's usually why states are in opposition to Indian country, because they want to be able to tax those business ventures. Yeah.
I got a question. So on reservations in the United States in the lower 48, is it generally the tribe that has like the title to that land? And if it doesn't, then is that land held by the government, restricted by the government in terms of development and how you can use it? Is that what into trust means?
Yeah, so it's completely backwards. So in order for a tribe to exercise its governing authorities, its jurisdiction over the territory, it has to give its fee simple title to the government, and the government holds it in trust for the tribe. So now the government has my title, and it's held in trust for the tribe or for the individual in the case of like an allotment. And so you have to give away your free and clear title in order to have these rights to govern, which is completely screwed up, right? It's backwards. It should be like, this is our land, it is ours, we can govern it. Yeah, but it's not that way. And you are severely limited in what you can do. There are, even with leasing, like finally Interior revised its leasing regulations within the past 5 years, because it was like the land was so tied up, you just couldn't even lease it to people. Also, it's hard to get a mortgage, to get financing for stuff. There's all kinds of restrictions. But I think that the feds have been trying to figure out ways to help not be such a blocker of actual like beneficial use of the property. But yeah, so any tribe that's looking at fee to trust really has to consider these things really carefully. And there's a manual on the BIA website that says step by step what you have to do in order to go through the process. And one of it is like talk to other landowners locally, because one of the big concerns in Alaska is, well, if you're going to tie up land, if a tribe so our tribes in Alaska are sovereigns without territorial reach. They don't have land unless they ended up with it somehow, like in Venati, where the village corporation gave them the land. So basically the tribes have to get land from somewhere, and a lot of the time, if it's former ANCSA, if it's ANCSA lands, the subsurface might be owned by the regional corporation, and like the surface may be owned by the village corporation, and then if the village, because that's what ANCSA did, it gave the surface to village, and it gave to regional corporations subsurface and surface on their lands, but the subsurface of the village corporations is owned by the regional corporation. So if then like the village corporation gives the tribe lands, but the regional corporation owns the subsurface, what does that do to that regional corporation's subsurface estate? Is it then going to be locked up because the surface is in trust? And those questions haven't been answered, and so I think that's why some regional corporations are like, hang on guys, like we need to understand these things before we go out putting land into trust. So it's another one of those things that could be useful, but you don't want to just go do it without knowing, really analyzing what you're doing, because you could end up kind of, if you don't have all the information you need, you could really end up in trouble.
45 years after ANCSA, there's still tons of questions about land and Alaska Native ownership of land in Alaska. And as you think about the challenges you all will face as leaders going forward, these are those. These are who gets what, and and understanding why people want it, because there's some money.
Yeah. So that's Venati. So John V. Baker, just going back, so we kind of talked about these things, but John V. Baker was a really critical case in Alaska that emphasized that tribes have inherent sovereign authority over their members, even without Indian country. So tribes still have rights, even if they don't go file for fee to trust and get, have Indian country. Tribes can decide child custody and other matters to protect tribal self-government or to control internal relations. Here's this comedy. This is where the court talked about comedy. So tribal court judgments are entitled to comedy in state courts, which we already kind of talked about. Next slide. Subsistence. And this is one of the last, we have a few slides on subsistence, but so issues. ANCSA extinguished Aboriginal hunting and fishing rights, but the congressional record, which I actually was just digging in this week, it's pretty thin. It's very thin on ANCSA. It is painfully thin. But there's a section in there that says that the state and federal governments would protect native subsistence. And as the native leaders were in like AFN, because AFN was created in '66 to advocate across regions, to the federal government for land claims settlement. They all were not up for giving up subsistence. Everybody knew subsistence was critical. I mean, a lot of the people who were part of this lived the subsistence lifestyle. They were hunting and fishing, and the whole point to them was to have land upon which we can be. And what do we do when we're being? We hunt and fish, we hang out with our families, we go pick berries, we just are who we are. And so they wanted to be on that land. So a previous, I think there were 4 iterations of ANCSA before it passed, and I really want copies of those initial drafts, but I couldn't find them. But some of those drafts protected subsistence, Alaska Native, Aboriginal hunting and fishing rights. But what was passed, and so there was the House, basically there was a conference committee between the House and the Senate that had to come together ultimately and they spent 9 days hammering out the final version of ANCSA, and when they came out of that room, and of course they had no Native leaders in that room, it was just Congress, there was no subsistence protection. But the congressional record clearly states, and I should put a quote, that the state and Interior were going to protect Alaska Native subsistence rights. That never happened. They never really created a beefy program for that. But what they did is they passed the Alaska National Interest Lands Conservation Act, which is a huge statute that created a lot of parkland, and it actually impacted the lower 48 too. It has provisions that address down there, even though it looks like it's just Alaska-centric. But it provides for the rural preference of hunting and fishing rights. So it says that in times of scarcity, like when there are low fish escapement counts, that rural people will get a preference. And in order to actually set that in motion, somebody has to petition the feds to, issue a rural preference. And that happened on the Kuskokwim a couple of years ago. It's been happening more and more. Right now, the caribou herd up in Northwest Alaska has a rural preference on it right now, for I think the first time. So that's the subject of a lot of debate. A lot of people think that needs to be amended, there's just debates about if it needs to be amended to say there's a native preference, or they'll say a rural plus preference, so a rural plus native preference, so that still rural Alaskans will have a preference to subsistence resources, but it would specifically state in there Alaska Natives are too. So that's an issue. It's going to continue, particularly as resources get strained more. Next slide, please. So kind of a conclusion on land. Through this whole presentation and sort of the foundational law and stuff, Alaska Natives had exclusive tribal use and occupancy of land, Aboriginal title, like other Native Americans. ANCSA extinguished it, left tribes without Indian country until present, perhaps. ANCSA corporations own 4 to 4 million acres in fee simple title. Next slide, please. Subsistence is unresolved. We just talked about that, so next slide, please. And then sovereignty. Tribes still have inherent sovereignty over internal relationships and self-governance, consensual relationships with non-members, matters vital to tribal integrity and self-determination, and matters preempted by federal law. So that's the end of this presentation. But I think, in general, I want to encourage this generation to not just line up on one side or the other or whatever. I think that our real creative thinking about how to address some of these issues is going to be needed. We can think of ourselves as peoples, just like the peoples gave their authority to the U.S. government. They delegated that authority through the Constitution, right? But it was the people. So we are the people, and we can, use these different tools we have, ANCSA corporations, tribes, tribal organizations, as tools to further our community's goals. And a lot of the times the goals of everybody are the same. Sometimes they differ, but it's really about, improving the quality of life for our people, having healthy people, reversing a lot of those crappy social ills that are still plaguing us, economic development now that we're involved in this capitalistic society, and the ability to continue hunting and fishing, because that's a need and a really big part of Alaska Native culture. So.
Yeah, I think I first met Liz probably at AFN.
Yeah.
And we were both, she was in the room either as a representative or board member or in some capacity, and I've been on that board for a few years now. And there came a point in AFN's history about 4 or 5 years ago now when there was a very concerted effort to expand the membership of AFN to include tribes. Well, tribes had always had an opportunity to be what's called a Class B non-voting member, and they didn't have a seat on the board of directors of the Alaska Federation of Natives, because originally the Alaska Federation of Natives was first the Alaska Regional Corporations, and then it was the health corporations that were, or the native nonprofits that were added to it, and then villages. Didn't say village corporations, it just said villages. And there was no mention of tribes in AFN really. So a number of us got involved in trying to basically update the bylaws. They hadn't been changed for about 40 years at that point, and freshen it up, put in some modern nonprofit governance structures, and to specifically include tribes. And it turned out to be one of the most difficult negotiations I've ever been involved in my entire life. And it was for some of the reasons that we're talking about here, because there at AFN you've got a lot of elderly leadership that has very set concepts of themselves and the people that they represent. And in Alaska, people are tribal members, they are corporate leaders, they are heads of their nonprofit associations. They're wearing all these different hats, and a lot of people in the room felt there was no need to call out tribes because they were implicitly already in AFN. And one of the reasons that I thought it was important to explicitly recognize tribes and to give tribal entities a seat on the board of directors was, first of all, what's inherent in being one of the decision makers on a board of directors. And also importantly, what was going on with the Obama administration, where tribes had risen to this point that they hadn't been in forever really, where they had more and more recognition by the federal government, more and more funding was coming their way, and the opportunity actually to build these partnerships between all of these Alaska Native organizations could be really beneficial for AFN. But I can tell you that it took 3 years of going back and forth and just relentless convincing, which came down to a very close vote at the end of the day, to have AFN modernize itself and expand into tribes. And it's just one example of the tension that we're talking about, but the opportunity that exists right now to do these partnerships, to take advantage of all of our tools in the toolbox. I think it was last year, if you listened to, who was it? Who talked about tools in the toolbox? Do you remember, Carol? It might have been 2 years ago with Chris McNeil. I know Byron has talked about those sorts of issues, and so has Professor Hensley. But the idea is that we have all of these amazing organizations and strengths that we've developed now here in the 21st century. And rather than creating these tensions between ourselves, why don't we just work together as a variety of organizations with different missions, but from the same heritage, and use that strength. So it's kind of where things have gotten to because of this unique shift in federal policy that was ANCSA. So from your perspective, you're a young leader. What do you think the future is going to be for these organizations, kind of fostered and created by ANCSA? What do you think? I mean, what are the issues that are bugging the heck out of you these days?
The state fiscal crisis. That's a big one. I mean, that impacts a lot of our people, and I mean, a lot of our ANCSA corporations are involved in oil company support work, and so I think that, and also the cutting of the budgets. I mean, a lot of the programs that were cut are those fundamental ones that people need, like the social services programs to get behavioral health services and stuff like that. That's a critical area, because if I think that we've figured out more or less how to run businesses. Tribes have more or less figured out how to run themselves. There's still tons of capacity issues, but there's at least a baseline knowledge there. But if we don't address some of these historical traumas, I think we're going to keep kind of the cycle. And I kind of imagine a day when, we're not in a room and like almost every Native woman in the room has been sexually abused. If you look at the Tribal Law and Order Commission report, like it's like 4 out of 5 women or some, I don't want to misquote it, but it's insane. Any room you're in where there are Native women and men, people have been abused, and that's screwed up. And I don't blame us necessarily. I mean, every person is responsible for their own behavior, but when you've been living under when your relatives who, have raised, so, I was raised by a dad and he was raised by a mom. She was raised by a mom who was not a citizen, whose religion, as we saw in the Treaty of Cession, wasn't recognized, who didn't get to enjoy her possessions, these fundamental human rights, okay? So I think, and so my grandma was a drunk on the streets, that's where she died alone in Fairbanks. And that obviously impacts my father, who was then raised by missionaries and was ultimately adopted, thank God, by a good family. But there's trauma there that is like very real. And that, of course, I'm parented by a father, and he's Willie Hensley. He's this like Professor Hensley. He's a well-known Native leader, but he has experienced trauma, and I've experienced trauma. And so when the state government is trying to figure out how to balance its budget, it has a $4 million fiscal gap, and the way that it is fixing that is to cut social services programs and cut education. It's like, we're going to retrocede, There's been progress, particularly with Alaskan Native tribal health corporations using the Self-Determination Act compacts and contracts to be able to get monies in to provide these services. There's not enough money. And think about where we're providing services. So Anchorage, the services here are great, but like in Northwest Alaska, there's Kotzebue, and then they're villages. We do what we can with the resources we have, and it's remarkable because we're in the Arctic, we're using telemedicine, which is fantastic, but we need more. And the statistics and the crime and the abuse of children shows that we need more. And so that's where I think huge focus is needed. I know Greg's been focusing on he was a huge part of the crime reform bill to try to start turning the tides on some of these issues. Because until we get a handle on them, we could be the richest natives in the world and still be screwed up. There's other fundamental infrastructure that I think is needed in rural Alaska that somehow needs to be there. For example, childcare. Because when you have a childcare facility that's licensed, so there are basic like safety standards being met, like people can bring their kids there, they'll know they're safe. The people who are there will have had background checks, and then those people can go to work and they can generate revenue for their family and participate in the regional economy. But when you don't have that in place, I think that really stifles economic development. And like, we had to move our family back to Anchorage because we didn't have a safe place for our kids to be. And we wanted to be there. We wanted to be in Kotzebue. We were there for a year and a half. It just wasn't working. We didn't know our kids were safe when we dropped them off. And we loved the people who we dropped them off with. They were great people, but there's not the same standards in place. Like, you never know who's coming to visit. And my relatives, just like many of yours, probably have alcohol problems, are child abusers. It's just real. And so those sorts of things need to be addressed. So that's why I think we do need to keep making money with our regional village corps. We need to keep the money rolling to our tribes. We need to keep the money rolling to our regional nonprofits, because we need to address these social issues. Yeah.
I think that it's interesting to me when I think about the financial crisis in Alaska too, related to what you're speaking of. And specifically, I think that, we hear a lot that they're cutting anything in social services that isn't a critical function or a critical department. And I always think to myself, who's advising what is critical? Because I think that the critical services that they're keeping in place are reactive services, not proactive services. And so if you think of OCS and intake and, you know, even other basic things, you know, police force and fire and, you know, all of this stuff, I think a lot of them are just reactive services, not proactive, and we're never gonna get ahead of it if we can't have advisors to what is a critical service, you know, that think about what is the proactive critical service to prevent us having to be so reactive with these services, you know? I don't really know how to get ahead of that, but I feel like that is where we have to get somehow, what is a critical service? And to me, it's more of the proactive stuff and you know, addressing it earlier.
I think, you know, if one thing happened from criminal justice reform this year, it was the pretty broad consensus that prevention was cheaper than incarceration, right? And that kind of forms the basis over a lot of what drove a change in the criminal law. So, you know, I think what you're saying has a lot of merit to it.
Yeah.
Other questions for Liz? Yeah, go ahead.
So this is a question for either or both of you. So INCSA was kind of a compromise and a trade-off that created structures in Alaska that are different than the lower 48. So when I hear this talk and this evolution of tribes having land in trust and having the Indian country rights and taxation and so forth, it strikes me as having it for the Alaskan entities having sort of a both and type of situation. We've got corporations, but now we've got tribes that have tribal rights and Indian country rights. I'm just wondering if there's kind of a potential downside to that from a regulatory standpoint. You know, hey, you can't have it both ways. You're either this way or that way. Any thoughts on what some of the unforeseen consequences might be?
Is it really two bites of the same apple?
I think we can never get enough. I mean, Native communities need all the resources available in order to be healthy, I think. There could, I don't know, that's a really good question. Is it seen as,
Evolution of, for instance, of the 8A program and how it's restricted and how some of the broader opportunities there aren't as broad as they were. And it seems to me that regulatory authorities are always, you know, seeking to take things away. So the more that you expand these rights and these opportunities, perhaps someone out there somewhere might want to take other opportunities away.
Well, that highlights the continuing significant challenge for everybody in this room, because what you're saying is absolutely true. You know, we've seen in this laundry list of law where rights come and go at the whim of the government, and there's very little that, you know, the people that are subject to those rights can do about it. And so, yes, it's a fight that I fight every day, that Liz fights every day, because there are constant forces that, you know, give on the one side and take away on the other. And it's just, and you have to watch like a hawk, right? You have to be in the Federal Register and read it and see, you know, good Lord, who thought this one up? And then you have to consult, demand consultation, you know, participate in the public process, make comments when you see something that's wrong, because there is the possibility for change. You know, when the Tanunak decision that Liz talked about on the grandparents' rights happened, it was Alaska Legal Services, who I've worked with for many years. They were on the side of the grandmother, and the state had taken away her grandchild and put that child into foster care. And the U.S. Supreme Court had said, well, you know, in order to participate in adoption proceedings, you have to file adoption paperwork. And the Alaska Supreme Court said, that's the law of the land. We have federal supremacy. That's the law of the land. Even if we disagree, we couldn't do anything about it, so that's the law. And it took a number of outraged people, including legal services and the Alaska Federation of Natives to go to the governor and say, hey, this isn't right. And so we went through the steps. We went to the Department of Health and Social Services and talked to the commission, and we said, hey, this isn't right. And they issued emergency regulations to change it. And then the government said, okay, governor said, let's do a law. So he wrote a law, and then we went and tried to pass that law, and we did it. You know, so you can be involved every day right now to fix these sorts of things. Otherwise, yeah, they get taken away. Yeah.
I had a question that whole decision that happened at the end of the ANSA at that 9th hour around subsistence really caught my attention when I was prepping for the class. So I wondered if there's any knowledge of what got traded for it. You know, it just seems like such a core basic part of that kind of an agreement. So did someone give something up? Was there some kind of a negotiation? What got swapped for that in that 9th hour?
I don't know.
Yeah, there's really, I haven't seen legislative history on it. I mean, it happened behind closed doors.
Yeah.
There was lots of pressures going on. There was a fight over how much money should be given to these new corporations.
And how much land? Yeah, I mean, at one point it was like 10 million acres, and yeah. But that's such a good question.
He said something like, the state said, don't worry, we'll take care of them. You know? And everyone said, oh, okay. I mean, that's just so ridiculous to think that
Yeah.
that could be the agreement, and that there were no Alaska Native leaders in the room to agree to it. I'm just blown away. I
Well,
can't
and
figure
think
out.
of all the people testifying in front of Congress. They weren't just Alaska Native people. They were
Right.
states' rights people. They were
Oil
big
companies.
oil companies. You know, they were the state of Alaska.
Mhm.
It was not on our side. I can tell you that.
Mhm. Yeah.
We've talked a lot about changes, changes over the last 45, 50 years. There've been a lot of cultural changes. There's some demographic changes. For example, in our region, in the inner region, there are now more Nana shareholders living outside Northwest Alaska than there are in our region. And as all these changes occur, can you guys address what you see today of the corporations' role as culture bearers, or well, we could say we call responsibility to thrive?
Yeah, I think there are kind of there's just always questions. For example, in our region where more shareholders live outside than inside, it really begs the question, well, when the company is investing in regionally based stuff, you know, to what extent can it do that, because it's not seen to be benefiting all shareholders, you know? So that type of question is out there because you know, people, yeah, so there's that. There's also, every company is different. Right now, Nana's having a hard time, so you see, like, when they're having a hard time, positions are cut, and you see that cultural programs line item goes, and it's like, this sucks, maybe, you know. And then with tribes, those template IRA constitutions, they're interesting because they say that basically if a tribal member has left the village and they don't intend to return, they can be disenrolled. I don't know of any, I've never actually seen a tribe just disenroll a bunch of people because they don't live there anymore, because I think that there seems to be just a recognized transience of our people. But that does sort of beg the question of, like, when a tribe has money to issue scholarships, for example, do they make it available to all tribal members, even those living in Wasilla, or just those living in the region? And I've seen some very heated debates about that, very heated, with, on one hand, people being like, these are all our people, we want to support them, and maybe when they get their education, we can, you know, entice them to come back to the region and work in our schools or at our company or whatever. And then there's the other people saying, hey, the people in Wasilla, they have so many opportunities to go do cool stuff, to, you know, to find other scholarships. to go participate in all these cool educational opportunities offered there that aren't offered in our village. So no, this needs to be limited to our residents, or people in the region or in our village. So I've seen just really, really heated debates, and
Down south, this enrollment is a huge political tool, especially when casinos are involved, casino payouts are involved.
oh yeah.
Increasing the amount of payouts.
Okay, last question to Cindy. You have your hand raised?
Well, it's more of a comment. I thought maybe some heated discussions, and some people say, well, you should be thankful for what you have. You guys really have a lot more than what they have down south, and I'm absolutely thankful for what our leaders have gained for us through ANCSA. But I think as Alaska leaders, we're going to have to continue to fight for more and work together as corporations, working with our tribe and our community. We really see ourselves as we support the tribe financially and provide different resources to them to help them thrive, because we know if we work together, we're going to be able to help our community. And I think it would also be interesting to see kind of an analysis of what we did give up. What did the state gain? What did the feds gain off of all of this land in Alaska? And that's going to really show, $3 per acre for what we have. But, it's not a whole lot.
Mm-hmm.
Well, it came to the point where the decisions had to be made. This is what we got. So, with that, we want to thank Liz. These days, I don't even email people to ask them to come to class anymore. I just texted her this time. And so I really appreciate you agreeing to do this one more time and talk about these laws from a lawyer that's seen so much of it. And on behalf of APU, I'd like to thank you too.
Thank you. Yay. Thanks.